Mediation versus arbitration, what every business executive and in-house counsel should consider in its critical documents. I am pleased to welcome my colleagues, Brendan O'Toole and Lauren Fussell. Brendan is a partner based out of our Richmond office and has been with Williams Mullen for 17 years. His focus is on complex federal and state commercial litigation with an emphasis on contract disputes, residential development and construction, and the defense of business, tort, and class action claims. He also regularly defends clients in shareholder disputes and against claims brought under various consumer protection statutes. He is a former law clerk for a federal judge in the Eastern District of Virginia. Lauren is a senior associate with Williams Mullen and based out of our Raleigh office. She helps clients navigate complex legal issues that are often a direct threat to their ongoing operations or, in some cases, their liberty. Her experience includes representing businesses and executives in all phases of complex civil litigation, from fact investigation through trial. She has experience litigating claims related to contract enforcement, fraud, breach of fiduciary duties, unfair and deceptive trade practices, and intracorporate disputes for clients across industries as diverse as telecommunications, healthcare, financial services, and real estate. Brendan and Lauren, take it away.
Bryden, thank you very much. We are happy to be here, hopefully give you all some knowledge about the differences between mediation and arbitration, and more importantly, how you can use those different avenues to your advantage, and some tools and tricks that we hopefully can impart on you all today that will help you with your contract drafting and what to expect as the either mediation or arbitration process unfolds. We're going to start with Lauren, who's going to talk a little bit about the basics of mediation.
Morning, everyone. If you are a litigator or tangentially involved in litigation, you have probably heard about mediation. Maybe you've participated in one. But before we start this program, Brendan and I thought it would be helpful to make sure you know really what is mediation, what is arbitration, so that you can make an informed decision about what is best for you and how to appropriately write or revise your contracts as needed. So most of this will be a reminder, hopefully, but mediation is where we have a third-party neutral who facilitates a resolution discussion between the two disputing parties. To keep our state bars happy for CLE credit, I'm going to mention that mediation is generally governed by state statute. Both North Carolina and Virginia have statutes defining mediation as a process where the mediator facilitates communication, but does not decide issues, does not impose solutions, but enables both of the parties to mutually understand the other side's position and their resolution position. Mediators are impartial third-party neutrals that may be selected by agreement, or particularly in North Carolina, if you do not come to an agreement about your mediator, you may be assigned one from a random list of people who have been certified. Both Virginia and North Carolina have standards for mediators before they can be certified. These standards are promulgated by the various state Supreme Courts, but generally require the mediators to go through training, do a number of observations of mediation, do some hands-on practice, and make sure they are aware of their obligations and their ethical rules. As a reminder, and often I find it helpful to remind my clients as we are preparing for mediation, especially if they haven't done this very much before, mediators do not decide issues. The mediator is not going to come in and call balls and strikes. The mediator is not going to come in and say, well, Ms. Fussell and your client, I agree with you 100%. You are winning this case. Congratulations. You have won. They aren't going to do it. They aren't going to decide issues. They are also not going to impose requirements on the parties to produce information or disclose something. They can't require parties to make offers, or they can't require any type of settlement or particular solution. What they do is strictly facilitate discussion between the parties. As a reminder, parties can agree through contract or otherwise to submit their dispute to a pre-suit mediation. We can talk about a little bit about this later on of the timing of mediation and when it's appropriate, but you can do this before you even get to a full-blown dispute that goes to litigation or arbitration. And sometimes that can be really helpful and really beneficial to clients. Whether or not you do a pre-suit mediation, at least in North Carolina, if a lawsuit is filed, you are then going to be ordered to mediation almost without exception. If you are litigating against the government, or very few other exceptions that don't come up very often in business civil litigation, you are going to be ordered to mediation by the North Carolina State Court or the federal court. So be prepared for that. It should not be a surprise when you get a standard order coming out of those courts telling you to select a mediator and go to mediation at some point. My understanding is that it's a little bit different in Virginia, and you may have some avenues to maybe not be automatically ordered to mediation, but it also happens in Virginia, and you should be prepared in the event it does. So I think we're going to go to our very first official polling question this morning after Bryden's practice. So if we could bring up the first polling question. Before we turn to allowing Brendan to explain what arbitration is, we want to get to know a little bit more about the arbitration contracts and provisions you might be dealing with. So polling question number 1. We'd like to get to know more about your business's contract provisions related to arbitration before we get started. Which of the following is most true for you? Option 1, our standard contracts do not include a mandatory arbitration provision, but our counterparties have mandatory arbitration clauses that we consent to. Option 2, our standard contracts include a mandatory arbitration provision. Or option 3, I don't know whether our standard contracts or our counterparties contracts include an arbitration provision. You have a little over 30 seconds left to answer this polling question. There is no right or wrong answer. This is a gimme, but to get CLE credit, we do ask that you respond to each of the polling questions, including this one. I make no promises that Brendan won't ask you harder polling questions as the CLE continues, but this one should be easy enough. All right, here are our results. About 43% of you said that your contracts have a mandatory arbitration provision. 31% said your counterparties do, and about 26% of you said, well, I don't know. Brendan and I are going to talk to you a little bit about why we think you should find out if your contracts have mandatory arbitration provisions and what those arbitration provisions say. If we can go to the next slide.
So that polling question was really interesting because there are plenty of folks on the call who do not have mandatory arbitration. There's some that do. There's some who do not, and their opponents do, and some who aren't quite sure if they do or they don't. So you're at the right CLE. We're going to help you get these issues sorted out and decide whether arbitration is something that you should consider incorporating into your contracts to either level the playing field or to make it more advantageous for you when a dispute does arise. So what is arbitration? Everybody agrees, essentially, when a dispute comes up, to have a neutral third party, that's the arbitrator, hear their case. During the arbitration hearing, each side lays out their points, presents evidence that they have. But unlike the typical courtroom setting, the procedures are a bit different, and the arbitration proceedings stay confidential. Any transaction that touches on interstate commerce is governed by the Federal Arbitration Act. Virginia has the Virginia Uniform Arbitration Act. North Carolina has an arbitration statute. South Carolina has an arbitration statute. You may be saying, well, what is something that touches on interstate commerce? How would I know whether my state arbitration statute or the federal arbitration statute controls? Well, think of a dispute between two North Carolina companies and individuals who also reside in North Carolina. And the dispute concerns the construction of a commercial building in North Carolina. In that situation, the North Carolina Revised Uniform Arbitration Act would likely govern that dispute rather than the FAA. For you to get into arbitration, you got to have an agreement. There's got to be an agreement to resolve the dispute by arbitration, and the arbitration provision has to cover the dispute. If you don't have an agreement to arbitrate, there's no obligation to arbitrate. And so what do you do if you do have that agreement? You move to compel arbitration. And the federal and the state arbitration statutes all say that the court must direct the parties to proceed to arbitration if there is an agreement to arbitrate. Now, there are some certain exceptions. I can't cover all of those exceptions today, but there are situations where you even may have a binding, you think it's a binding arbitration agreement, but it's not enforceable. All of us remember the Me Too movement. That was around 2020, 2021. In 2022, President Biden signed the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act of 2021. Which made it unenforceable for pre-dispute arbitration agreements regarding any sexual assault or sexual harassment dispute, unless that's something that the claimant desires to do. So that was something that was taken off the table. In Virginia, where I practice, you can't have an arbitration agreement between the Commonwealth and its employees. Controversies regarding the employment or terms of conditions of employment between Virginia and its employees are not subject to arbitration. What about the rules in the arbitration context? Well, the good thing about arbitration is in a contract, you can decide what you want the rules to be. Do you want the American Arbitration Association rules to control? Do you want construction rules to control? Employment rules to control? Do you want JAMS consumer rules? Do you want to have the federal rules control? Something else? You get to decide in your contract which rules you want to have apply. Arbitrators are people who are typically trained and appointed through commercial arbitration organizations, or they can be people agreed to by the parties. They can be lawyers who specialize in a certain area. They can be retired judges. One of the big things about arbitration, no juries. You don't run the risk of having a number of people who you've never met before figure out if your case is a winner or a loser. One interesting fact in kind of preparing for this presentation I found was that in Virginia, a party has the right to be represented by an attorney at any proceeding or hearing under the Virginia arbitration statute. I didn't know that. I imagine a lot of people also may not have known that. I've never seen that enforced before, but it's something interesting to keep in mind that everybody has the right to an attorney in a Virginia uniform arbitration proceeding. What happens once the arbitrator makes a decision? They get an award just like any other award. It's only as good as the paper that it's written on. So what you have to do is you've got to take that award and get it confirmed by a court so that it can be enforceable. There's not a lot of discretion the courts have on confirming an award unless there's some really extreme reason to not confirm the award. And I can tell you, once you get a decision, it's normally a one-shot deal and you're done. There are not very many appellate rights in arbitration. So whatever the arbitrator does, that's pretty much the result you have to live with, win or lose. And it's very, very difficult to overturn an arbitration award. It's just next to impossible. It's the way that I would describe it. There are specific statutory grounds, but they're really extreme. Like the arbitrator was corrupt. The arbitrator was partial. The arbitrator exceeded his or her delegated powers. But it's not, you don't get to vacate an arbitration award just because you don't like the result, or even because you think that the arbitrator didn't apply the law correctly, or totally whiffed on a legal principle. That's not going to be enough to vacate an arbitration award. So that's a little bit of the background with that. Let's go to the next slide now that we've covered some of the basics. All right, recent cases that have interpreted arbitration clauses and statutes by the Supreme Court of the United States. These are important. Want to get to these because arbitration has been a central focus of the business community and the consumer community and I'd say probably the last 15 years. Almost every single term within the last 15 years, there's been some major U.S. Supreme Court case that has decided various aspects of arbitration. One of those that is most important and that I think is practical to folks on this call is if I've got an arbitration agreement, how soon do I have to try to invoke it? If somebody has filed a lawsuit against me and I want to arbitrate, do I have to move to compel arbitration immediately? Can I wait a little while and do it later? That's what this case, Morgan versus Sundance, addressed in 2022. And the bottom line with that is when you've got an arbitration provision, you got to use it or you lose it. It's hard for you to litigate on the merits of a case and then say, well, wait, sorry, judge, I don't really like where this is going. So I've got this arbitration provision, and I think you need to send the case to arbitration. The facts of the case, Morgan was an hourly employee at Taco Bell. When she applied, she signed an agreement to arbitrate any employment dispute. And she ignored that agreement, filed a nationwide collective action against Taco Bell, saying that she and other similarly situated employees had been denied overtime pay under the Fair Labor Standards Act. Taco Bell initially defended the case. They filed a motion to dismiss. They participated in mediation. 8 months after the plaintiff had filed her lawsuit, Taco Bell did an about-face and moved to stay the litigation and compel arbitration. And so did Taco Bell, the question that I have, did Taco Bell waive its right to arbitrate? And we don't have a polling question for this, but you might be surprised to learn that there was a unanimous opinion by Justice Kagan. She said the answer is maybe. Maybe they waived it. That's often the answer with legal questions. But the bottom line here was that the lower courts applied the wrong analysis. And so they sent the case back for further fact development. And the key holding is that you can waive your right to arbitrate by first litigating claims, even if the other side is not prejudiced by the conduct. So prejudice to an opponent plays no role in determining whether there's been a waiver of the right to arbitrate. So the key takeaways from this case are, one, the Supreme Court has made it easier to find a way to find that a party has waived its right to arbitrate, because you don't focus on what the opposing party has, the effect on the opposing party. Supreme Court has told us you use your right to arbitrate or you lose it when it comes to arbitration rights. And the second important takeaway from this case is it effectively abrogated and overturned 50 years of Fourth Circuit precedent that required prejudice to show waiver of the right to arbitrate. So you don't have to show prejudice. Let's go to the next slide and see how the lower courts have applied Sundance. This was a Fourth Circuit case that was decided about a month ago. It's called SZY Holdings versus Garcia. And I thought it was important that we see how the lower courts are applying this whole waiver concept after the Morgan decision. This was a case that concerned contracts to supply hand sanitizer at the beginning of the pandemic. The contract had an arbitration clause. In November 2021, it's SZY, but I'll call it CISY. CISY sued. The defendants didn't respond, so CISY got a default judgment in March of 2022. A month later, the defendants moved to set aside the default judgment and argued in part that proper venue was arbitration. The default judgment was set aside, so CISY filed an amended complaint. Now we're in June of 2022, so we're about 9 months after, and the defendants moved to dismiss on the basis of, quote, preemption based on a binding arbitration agreement, and they moved to dismiss on other grounds. And at the hearing, the defendants asked for the case to be sent for arbitration, but they still hadn't formally moved to compel arbitration yet. A month later, the trial court denied the motion, the defendants sought reconsideration, and then this time, for the very first time, they moved to compel arbitration, which was also denied. 9 months passed between the time the defendants were sued and when they formally moved to compel arbitration. And so it's time for our the next polling question. So in light of these facts, did the defendants waive their right to arbitrate? Yes or no? I'm going to open up that polling And again, this is a situation where the defendants waited 9 months before they formally moved to compel arbitration and knew that they had an arbitration agreement. Did they waive the right to arbitrate? All right. So a few more seconds. And let's see what those results are. So almost 70% of you said yes, they waived their right to arbitration. And about 30% of you said no. Well, you would be surprised, like I was, that the answer is no. The defendants did not waive their right to arbitrate. Before the Supreme Court's decision in Sundance, the court likely would have held the arbitration waived because the 9-month delay, of course, prejudiced Sizzy, the plaintiff. But here, although the defendants knew of their right to arbitrate, they didn't act, according to the Fourth Circuit, inconsistently with their right to arbitrate. They consistently requested arbitration without formally moving to compel. They argued improper venue due to arbitration, preemption due to arbitration, asked for the matter to be sent to arbitration in their 12b-6. So the Fourth Circuit said, no, they had not waived the right to arbitrate, and they sent the case back. Many of you are probably thinking, well, how far can you go before you trigger the right, before you waive your right to arbitrate? I can tell you that the Fourth Circuit has said that filing an answer to a complaint does not waive arbitration. Generally, it doesn't. Generally, filing some sort of a responsive pleading, like an answer or a counterclaim, is not necessarily inconsistent with the intent to pursue arbitration. What about a situation where you misplaced the arbitration agreement or didn't find it until later in the litigation? Even that may be okay to preserve the right to arbitrate. Courts within the Fourth Circuit have granted motions to compel even where the arbitration agreement wasn't found until the discovery phase of the case and where the defendant had already filed responsive pleadings. So really, the bottom line is when it comes to waiver, it's very fact dependent. I looked at a case that was from the Virginia Court of Appeals, decided just last year. There was only a 3-month delay between the time that the party was served with the complaint and the time that they moved to compel arbitration. The Virginia Court of Appeals in that case said they had waived the right to arbitrate. So it really is fact dependent on whether you've waived the right to arbitrate or not. And we're ready for the next slide.
Tried to warn you that Brendan was going to ask harder polling questions than I would, but we're going to keep talking about some recent Supreme Court cases. This slide is regarding a stay pending arbitration. So these situations are where there is a case generally filed in, say, a federal district court to compel arbitration, and what happens to that district court case whenever a matter is ordered to arbitration. So the person seeking to compel arbitration wins and it goes to arbitration, what happens to the court case, and then in the second case we'll talk about if that party seeking to compel arbitration loses the motion and wants to appeal it. Again, what happens to that district court case where you might have dueling litigation? So the first case is Smith versus Spazzeri. This was a case that came out from the Supreme Court in May of this year. And the setup is this. A company that's a party to an agreement containing an arbitration clause files a lawsuit for breach of a contract. The defendant wants to invoke the arbitration clause in the contract and files a motion to compel the matter to arbitration. We're going to say we're in federal court here, should the federal district court stay the lawsuit pending arbitration or dismiss the lawsuit entirely? Well, this turns on the language of Section 3 of the FAA. This Smith versus Spazzieri matter really came down to a statutory interpretation argument and how the courts should apply Congress's words. So Section 3 of the FAA provides that the court shall, on application of one of the parties, stay the trial of the action until such arbitration has been had in accordance with the terms of the agreement. However, there was a circuit split about whether or not the FAA in that language permitted a court to dismiss the lawsuit instead of staying it when all of the claims are subject to arbitration. Because as the district court is looking at things, if everything from this case is going to arbitration, why am I going to keep a case on my docket, state or not? Why keep it here? Most of the circuits held that when a party requests a stay pending arbitration, the FAA requires the court to stay the lawsuit. A minority of courts held otherwise and gave the court's discretion of whether or not to dismiss the lawsuit. SCOTUS stepped in to resolve this circuit split in May of this year through Smith versus Spazzieri. And to no one's surprise, or it shouldn't have been a surprise, shall means shall in the FAA. That is what Justice Sotomayor, when she was writing for the court, tells us. She said, when a federal court finds a dispute is subject to arbitration and a party has requested a stay of the court proceedings pending arbitration, the court does not have discretion to dismiss the suit on the basis that all of the claims are subject to arbitration. I will tell you, I have been on the other side of this before Smith versus Spazzieri in May of this year came out. I've actually litigated this issue. We brought a lawsuit. The other side, the defendant, moved to compel us to arbitration. We initially had some dispute about whether or not the arbitration provision applied to the lawsuit, but eventually concluded it did. And we said, we'll go to arbitration, but district court, please stay this litigation while we do it. Maybe we need to come back to enforce it. Maybe there are going to be issues with the arbitration, who knows, but please stay it. Don't dismiss our claims and while we do arbitration. Over our request for a stay, the district court dismissed our lawsuit. Now with Smith versus Spazzieri coming out, I think that probably would have a very different result, or at least I hope it would. But the Supreme Court stepped in to resolve that circuit split. So that's what happens to the district court case if the motion to compel arbitration is granted. What about if the motion to compel arbitration is denied? Maybe the district court finds the parties had not actually entered into an arbitration agreement, or there were limitations on the arbitration agreement that limited the types of claims that were subject to arbitration, or as Brendan just talked about, maybe the party had waived their arbitration agreement in some way, or waived their right to arbitrate. So the district court, as we're going to talk about in Coinbase versus Bilski, which is a 2023 Supreme Court decision, it's essentially the same facts as above. There's a district court case. The defendant wants to compel arbitration, but in Coinbase versus Bilski, the district court denied the motion to compel arbitration. The defendant filed an interlocutory appeal of the denial. So Coinbase versus Bilski stepped in to provide clarity about what the appeal of a denial of a motion to compel means for the district court litigation. Does the district court stay it, or does the matter continue to proceed through litigation, through pleadings and discovery, while the appeal is also pending? The Supreme Court tells us from 2023 that when the motion to compel is denied and appealed, the district court proceedings should be automatically stayed pursuant to Section 16 of the FAA. So again, interpreting Congress's words in the FAA, Supreme Court tells us you have to automatically stay the district court proceeding while the interlocutory appeal proceeds. For any of our appellate practitioners out there, most of you know that interlocutory appeals are disfavored and they are generally not allowed to appeal intermediate orders if it doesn't fully resolve the case. And a motion to compel or denial of a motion to compel is considered an interlocutory order, so it's not ordinarily allowed a right to an automatic appeal. However, Section 16A of the FAA provided a statutory exception to that rule and specifically allows for interlocutory appeals of a denial of a motion to compel arbitration. So the Supreme Court came in and clarified, look, district court, if you deny a motion to compel arbitration, the aggrieved party is given the statutory right to an immediate appeal, and you cannot continue the litigation here. And that makes sense, right? Because the appeal is about whether or not the case should proceed in district court. And if the district court requires you to keep litigating the case in district court, and the appellate court ultimately agrees with the party seeking to compel the matter to arbitration, you've essentially nullified the appeal and nullified Section 16A of the FAA. So the Supreme Court told us we can't do that. We'll move to the next slide. We're going to talk about another Coinbase action. Coinbase is involved in a lot of litigation regarding arbitration. And this is Coinbase versus Susky. This is a 2024 decision from the Supreme Court. So it came out in May of this year. And here's generally the setup. And it's something that I think probably a lot of you may find familiar in your businesses or maybe in your personal life whenever you're signing all sorts of terms and conditions in apps and agreements that you're personally entering into. But here's the setup. When parties have agreed to two contracts, the first sending disputes about whether the matter is subject to arbitration or whether a matter is the arbitrability decision, that decision is going to the arbitrator in the first contract. There is a second agreement between the parties that sends the arbitrability disputes to the courts. So does the court or the arbitrator in that case decide which contract governs? And I think giving you a little bit of the factual background here is helpful to put in your mind how this could happen to you or to your business clients. So Coinbase is a crypto exchange platform, and it has users execute two agreements in this case. The first one is a user agreement to say, in order to use our platform, here are essentially our terms and conditions for you as a user. In that user agreement, it provided that the arbitrator would decide all arbitrability disputes. There was a second contract that Coinbase entered into with a subset of its users, and those were official rules for a sweepstakes that users voluntarily entered into on the website. And in the official rules, Coinbase included a forum selection clause that gave sole jurisdiction over sweepstakes-related disputes to California courts. The users filed a class action in California, alleging various problems with the sweepstakes under California law. Coinbase moved to compel arbitration, relying on the arbitration clause in the first contract in the user agreement. The district court ultimately denied the motion and held that the forum selection clause governed the dispute, and the appeals of this went up to the Supreme Court. In a unanimous decision by Justice Jackson, the Supreme Court clarified and told courts that a court, not an arbitrator, should decide if an arbitration agreement containing a delegation clause was narrowed by a later contract providing for disputes to be decided in court. So before a court is going to refer a matter and whether or not the matter is arbitrable to the arbitrator, the court must first determine what the parties agreed to, including as here, whether the parties had agreed to arbitrate arbitrability for sweepstakes-related disputes. So what the Supreme Court really told us here and told the courts here is, courts, it is your job in the first instance to really decide the scope of that arbitration provision if there's any question about whether or not a court or an arbitrator should decide that. Certainly your contract may say very clearly, any questions or any disputes about arbitrability are decided by the arbitrator. Clear enough. But where you have a second agreement in this case, or where you have some other question about whether or not the arbitrator or the court is required to decide the issue, the court has to, in the first instance, determine the scope of that arbitration clause and whether or not the arbitrator should, in fact, make that arbitrability decision. I will say in practice, at least in the districts that I'm in, a lot of times courts are very reluctant to want to step on the toes of an arbitrator. There is an arbitration agreement. If it conceivably gives the question of whether or not the matter is subject to arbitration and gives that decision to the arbitrator, courts are very often happy to say, "Oh, we can't do it. This isn't our question. Take it to the arbitrator. Maybe we'll see you later, maybe we won't." And I think that this Coinbase versus Susky matter really makes the courts look into that or question it. So the takeaway is also to be consistent with your arbitration provisions if you have multiple agreements, and be aware of this. So we'll go to the next slide.
All right. I don't know if everybody is familiar with what a click wrap agreement or a browse wrap agreement is. It's basically any kind of an internet contract where you have to scroll through and you click submit or I accept or okay or whatever to the terms of conditions. And so this next topic that we're going to get into is critical. If you've ever done work with a bank, taking your kids to an indoor trampoline park, used Zoom like we're using today, taken an Uber, bought tickets to a concert or an NFL game online, or as we're going to touch on later, bought tickets to the Disney theme parks, you have encountered these online terms and conditions. And almost all of them have arbitration provisions buried somewhere in those terms and conditions. Remember what Lauren just talked about. At its most basic level, you've got to have an agreement to arbitrate. What did the parties intend? That's the critical analysis. Everything used to be done on paper, but technology has changed the way we form contracts. This next case, this Georgetown Hospital case from, again, basically a month ago, is one of the most important arbitration cases that they have decided that I can remember. And it's going to apply to every single person's business that's probably on this Zoom call. Little factual background, the plaintiff applied for employment in 2016, checked an online box on the application agreeing to arbitrate any dispute with the hospital. Everybody agreed that this was a valid arbitration agreement. She couldn't submit her application until scrolling through the statement that included a quote agreement to arbitrate. And at the very end was a box to be checked and the words, "I accept." And by checking the box, the language said, "I accept." By clicking the "I accept" button, I'm agreeing to the employment statement, which contains an agreement to arbitrate. Now, this individual had to take an agility test. She failed it. She wasn't hired. She was not finished. She came back 4 years later, 2020. But this time the application process was a little bit different. As a returning user of the online application system, her prior information was already pre-populated into the current application. At the top of the web page was a submit button, and the top also said, "This application is subject to arbitration pursuant to South Carolina law." But only by scrolling down the page would a returning applicant like this plaintiff see the pre-populated acceptance of the arbitration agreement. If she had scrolled all the way down, before clicking submit, she would have seen her 2016 agreement with the "I accept" box already checked and her name and the date of when she had previously signed it. But as a returning applicant, she wasn't required to scroll all the way down the page in order to submit her new application. The plaintiff went through the agility test again, was rejected. She didn't get the job. She turned around and filed a class action alleging the test discriminated against women and the disabled. The hospital turned around and said, "No, you have to arbitrate. You signed in 2016, and in 2020, you clicked submit. And we put the information out there that is subject to arbitration." So the question is, did the plaintiff agree to arbitrate in 2020? And I thought, in looking at the factual background and kind of knowing the way that I read through this stuff, none of us read all these terms and conditions. We always just kind of scroll through, click "I accept" or "I submit" or whatever. And the Fourth Circuit said, no, They found the plaintiff didn't have adequate notice that the 2020 application was subject to arbitration. The court said that it wasn't enough that she could have scrolled down to see the arbitration agreement. She wasn't on notice that subsequent screens included the arbitration provision. She could have clicked the submit button since everything was pre-populated without ever scrolling down to the actual arbitration agreement. And if she could have completed her business by clicking submit on that one screen, there was no reason to presume that she would scroll to subsequent screens just because they were there. One of the questions that I had was, well, what about an obligation to read the terms of a contract? Don't we all have an obligation to read the terms of the contract? Yes, we do have that duty. And with paper contracts, you're rarely unaware that you're agreeing to a contract. You're rarely, unaware that you're agreeing to a contract or its terms. But when it comes to internet contracts, the duty to read is a little bit different. And according to the Fourth Circuit, they said the duty doesn't change into a duty to ferret out contractual provisions when they're contained in inconspicuous hyperlinks or can be found only by scrolling down through additional screens. So the big takeaways from this case, this Georgetown Memorial Hospital case, is make sure that if you've got an applicant for employment or you're asking somebody to sign any kind of a contract with an arbitration provision, make sure the applicant is aware of the arbitration provision and that they specifically agree to it. And again, like I said earlier, I get it. Nobody looks at all this stuff on their computer or on their phone when they're buying tickets to a Commanders game or going to the symphony and buying your tickets from Ticketmaster. But this case makes clear you have to require the person to scroll through the agreement in order to reach a submission button. Require the person to acknowledge by a signature specifically that they're aware of and agree to the arbitration agreement. That's really important. And state in the agreement that it applies to the current agreement, and Georgetown probably could have fixed the issue if they said this applies to the current agreement as well as to any future applications for employment that that person may have filled out. And then finally, you want to use broad language. If you really want to try to make everything arbitrable, any kind of dispute arising out of or related to this contract or agreement is something that should be arbitrated. Language that's something like that. So this was a critical case. It's in kind of a new technology space and is really important for everybody involved. All right, we'll go to the next one.
Case just confirmed my my very much dislike of requiring me to scroll through the entire terms and uses before I agree. But nonetheless, that is what the Fourth Circuit told us to do. This slide is for my fellow federal court jurisdiction enthusiasts, as I will call it. There's probably not a lot of you, but I will happily agree and admit to being one of them. The question is jurisdiction of federal courts when you're looking to compel arbitration or you're looking to confirm or vacate an arbitration award. So that everyone is aware, just because you are bringing a petition to compel arbitration pursuant to Section 3 of the FAA, that does not automatically give you federal court subject matter jurisdiction. It seems like it should because it is a question that is arising under a federal law. But the Supreme Court in a 2008 decision told us that isn't true. The FAA doesn't itself establish federal subject matter jurisdiction. So in 2009, Vaden versus Discovery Bank, the Supreme Court gave us some insight into this, and they said, well, what you can do is you can look through the petition for arbitration and see if the underlying question, meaning the underlying dispute, involves a federal question, and if so, you have federal subject matter jurisdiction through federal question jurisdiction. So if your underlying dispute is potentially a Title VII claim or FMLA or ADA or copyright or patent, something like that, if you can look through the petition and find federal question jurisdiction, that's fine. And of course, if you have complete diversity, that's a separate basis to get into federal court. But that Vaden decision left open issues about whether or not federal courts should have jurisdiction to confirm or vacate award. So in 2022, in the Badgerow decision, the Supreme Court, in distinguishing Vaden, actually said that if you were looking to confirm or modify an arbitration decision that's already been made, that look-through process that you could use on the front end to compel arbitration no longer applies when you are looking just to confirm an arbitration award, because in fact, the underlying question, the underlying dispute of ADA or FMLA or patent actually merges with the arbitration award, and the only thing the federal court is deciding at that point is whether or not to enforce an agreement to arbitrate when they're looking to confirm it. So just want you to be aware of those jurisdictional issues that may come up, and frankly may create some inefficiencies in your litigation where you may seek to compel arbitration in one court and confirm or vacate arbitration in a second court. So.
From a practical standpoint, Lauren, that it just makes little sense. I get interpreting the statute the way that it's written, but from a practical standpoint, when the Supreme Court has said, when you move to compel arbitration and it sends a case to arbitration, it has to stay the case in the district court. When you get an award and you come back to confirm it or try to vacate it, you can't come back to that same case that was stayed. You've got to basically now go to a state court and start all over to try to confirm or vacate the award. Is that kind of your takeaway?
That's generally my takeaway, and that's certainly the possibility, unless you have, diversity jurisdiction is the reason that you're bringing this suit to confirm and compel an arbitration award. So if you've got complete diversity between the parties and $75,000, you're golden in federal court. You get to stay. But this 2022 decision calls into question if you're solely there on some sort of federal question jurisdiction, which again is hard to get based on the look-through method. You may sort of lose your venue. You may lose your federal court jurisdiction when trying to confirm an award. I agree it is inefficient and seems to, it doesn't really square in my mind with making efficient litigation for parties. It seems to me it's just creating additional expense and problems. And unfortunately, I don't have a good way to square those decisions for you all. But I do want you to be aware of that so that you don't get surprised in the event the court says, well, I would like to confirm your arbitration award, but I do not have subject matter jurisdiction over this. Thank you. Goodbye. Go see a state court, and you are essentially starting a whole new lawsuit. So we'll go on now to talk about which one is right for your business. We've talked about mediation. We've talked about arbitration. So let's talk about a little bit of the pros and cons of these so you can think about which one is right for your business, or maybe both. So we'll talk about the mediation pros. We've got them listed up here. One of the main ones is confidentiality. I am obligated to remind folks on this that everyone thinks that as soon as you walk into mediation, everything a party says or does is subject to confidentiality. This is my warning to you that under North Carolina and Virginia statute and the rules of evidence under both of those states and the federal rules of evidence, that is not automatically true. The statutes prevent mediators from disclosing things. There's a federal rule of evidence 408 you've probably seen splashed across all sorts of settlement communications between you or your clients and opposing parties that say the settlement offer is subject to 408 confidentiality. Note that 408 is a rule of evidence, and a rule of evidence prohibits the use of evidence in a civil litigation trial for certain purposes. And so what I encourage everyone to do is ensure on the front end, if you are going to mediation, make sure you have an explicit agreement that everything said and done in that mediation is confidential. It will promote parties to really come to the table. It will promote them to exchange their thoughts freely, and you're likely to have a better outcome. But get that agreement explicitly in writing. Do not rely on the commonly understood belief that everything is confidential, because it may not be. A couple of other quick pros we'll run through is mediation gives the parties control. You're not waiting on a third party, whether an arbitrator or a court to make a decision. So it allows the parties to come to a win-win agreement, making everyone at least somewhat happy, as opposed to a win-lose agreement like you might find in court. Or what often happens is lose-lose. No one is happy with the court or arbitrator's decision. I think particularly useful mediation can be is allowing for creative or non-traditional resolutions. So if your dispute is over something other than just how much money I may be owed or I may owe for a set number of widgets, mediators can be extremely helpful in crafting non-traditional resolutions. This is especially true where you may be in an ongoing relationship with your counterparty. Perhaps they are a really important vendor to you, or perhaps you have other agreements with this counterparty and you're having a dispute over one, or you have some sort of master services agreement where you're going to continue working with this counterparty and having a business relationship with them after this dispute is resolved one way or the other. A really good mediator can help the parties get to kind of the crux of the business issues before them and develop a solution that may be something like amendments to an agreement or changes to agreement provisions that benefit someone in the long run over the business relationship. But thinking about that on the front end is really important. And then, of course, speed and cost can be a nice perk of mediation. Generally speaking, mediations are a day. You are just paying the mediator's fees, which aren't too terribly high for the most part. We'll go to the next slide and talk a little bit about the cons. The cons here are that settlement is entirely voluntary. Parties have the ability to and may withhold information or may withhold, their best and final offer. They may not make any offer at all to settle, and they may not really participate in the mediation process fully. And the mediator, because there are no formal rules, has no way to compel the parties to do that. And that can be extremely frustrating for clients who feel like they have just wasted their time to sit in a room with a counterparty that isn't really there in good faith. That's frustrating for lawyers. It's especially frustrating for clients feeling like they have wasted the time. So just a quick thought on when I think it is a really good idea to mediate. Again, if you are looking for a creative solution where you are working with the counterparty, particularly, I think it's helpful if you are in a small community where it is amicable. It's helpful to amicably resolve these sort of disputes through mediation and through something that's confidential. Those two issues can make it really beneficial to go ahead and go to mediation and resolve these through the confidential process. So we have our final polling question that we have got to ask for your CLE credit. So this is going to talk a little bit about arbitration. My company's arbitration clause includes a class action waiver. So my company cannot be compelled to arbitrate any class action claims. Is this true or is this false? As a reminder, for CLE credit, we do ask that you answer all of the polling questions and respond here. You have a little under 30 seconds remaining.
All right.
So it looks like our results are about 27% of you said that that is true. About 73% of you said that it is false. I will tell you that that was a little bit of a trick question on my part, but Brendan is going to explain to you on the next slide the answer to that.
All right, so let's go to the next slide. Arbitration pros and cons. We're going to get to the class action waiver aspect in just a second. One of the pros is you've got significant control. You get to pick the arbitrator. You don't have to use an arbitration organization, but it's probably advisable that you do. You can choose, do you want to have one decision maker? Do you want to have a panel of decision makers? And there's no risk of a jury trial. They generally are more efficient. You have a quicker resolution. I mean, I've got cases that I'm scheduling now for trial in late 2025. If you want to have a trial and arbitration in the next 3 months, you can do that. And arbitrators likely have fewer cases than their federal and state trial court counterparts. Costs, generally speaking, I think a lot of people believe that arbitration is cheaper than litigation because the parties can limit discovery and pretrial matters and things of that nature. We're going to talk about that a little bit in a second. You're not really bound unless you put it in the arbitration agreement by the rules of evidence or procedure. The arbitrators aren't necessarily bound by like formal civil rules of procedure. And so that can be useful to get to a quicker decision with all the relevant information before the decision maker without much of a fight or moving to exclude things and stuff like that. And one of the big wins for arbitration fans is privacy. Arbitration proceedings are not conducted in the public, where the parties file documents, briefs, and stuff that's presumptively available for anybody and anyone to examine and look at. And of course, there's no public trial. Another aspect is finality. It's really, like I said earlier, it's really hard to overturn an arbitration award, and usually there is very little appellate availability. And so getting to this topic that Lauren alluded to, can you limit class action claims? Generally, yes. Parties can waive the right to proceed as a class action as part of an arbitration agreement. And if you take nothing else away, put a class waiver in your contracts so that you're not. Class actions are incredibly expensive, incredibly high risk. So put a class waiver in there if you want to. To give you an idea, though, of how class actions can be limited, there are almost 60 million workers in the United States that are subject to mandatory arbitration agreements for employment-related disputes, meaning the employer requires as a condition of employment that the employee waive their right to sue in court. And in 2018, the Supreme Court held that such agreements are enforceable. But there's a new trend that's threatening class waivers, and it's called mass arbitrations. And this is where plaintiffs' firms or their firm will file tens or hundreds or tens of thousands of virtually identical arbitration claims, effectively creating a class action. That's why we kind of said you can have a class waiver, sort of. And it's made it incredibly costly, even if a claim is frivolous or a series of claims are frivolous, because it basically renders the class action waiver virtually useless. Let's go to the next slide. Arbitration cons. People think arbitration is cheaper. That's not necessarily true. Filing fees are, I've had one $2,000. Federal court complaints, $400. Initial retainers, thousands of dollars. You pay the arbitrator fees. I had an arbitrator recently whose rate was $1,000 an hour. What if I'd had a panel of arbitrators? You're obviously not paying the judge in court. In consumer arbitrations, you're responsible for all of the costs of arbitration. That's obviously not in the case in court. So things can be much more expensive than you might otherwise think. There's a little bit of a lack of transparency. Arbitrators have a lot of discretion on how proceedings are conducted. There's not a ton of oversight the way that there is in a public court of law. It's harder to research an arbitrator's prior case decisions. Some of that stuff's available, but not that much because it's all private. Other than some mandatory disclosures about potential bias, there's little that prevents an arbitrator from taking a bunch of cases related to the same party. So you may feel like you're not getting your day in court. And then is it really confidential? Well, what happens when you confirm or vacate an award? Then it has to become public. And then you're kind of at the mercy of the arbitrator. Sometimes arbitrators are unwilling to control the timetable. and the parties' conduct for fear of a challenge to a subsequent award. And sometimes arbitrators, because they know they're not limited by the rules of evidence, they try to make a decision that's, quote, more fair rather than the outcome that the law requires. And then the final con is limiting appeal rights. There's just very limited options when it comes to trying to challenge an arbitration award. There are some things that JAMS and AAA have done to try to combat mass arbitrations. I'm not going to get into all of that right now, but there are some things they've done to try to combat mass arbitrations from being filed and trying to limit the costs. So we can go to the next slide. Tips and tricks. Go to the next slide, please. We'll be brief with this. We know we're running short on time. Number one, know your contracts. Don't be surprised by an arbitration or mediation provision in your own agreement. Don't run the risk of waiver that we highlighted in the Morgan versus Sundance case. And like Lauren said, if you've got successive agreements, acknowledge the prior ADR provision and explicitly state that it's been superseded. Make sure there's an agreement to arbitrate. Have a clear statement up front informing the person that disputes are governed by arbitration. Explain the difference between litigation and arbitration and what the arbitration agreement covers. Put it in bold, put it in all caps, make it conspicuous. Make sure people agree to arbitrate or to the arbitration provision. Remember that click wrap agreement that I mentioned earlier from the Fourth Circuit case. Require somebody to scroll all the way to the bottom. Require affirmative acceptance with the terms and conditions. This area of the law is evolving. You may recall or have seen in the news an issue with Disney. A guy's wife got sick from an allergic reaction at a Disney restaurant. The husband filed a wrongful death case. Disney said, you got to arbitrate based on something that the guy signed for his Disney Plus agreement years earlier. And so Disney tried to enforce that arbitration agreement. The guy said, what are you talking about? I signed up for a Disney Plus account to watch Mulan with my kid, and now I can't file a lawsuit in court on behalf of my dead wife who ate something that she was allergic to at one of your restaurants. Disney ultimately backed off because of the public backlash, but they had some decent arguments in there that click wrap agreement did cover the claim that father had tried to bring. So those are some of the tips and tricks with arbitration. Remember to make it broad if you want to have everything encompassed under the agreement. But there's some nuances with this. And of course, Williams Mullen, Lauren, and I and others are always to help you put those agreements together.
I think that's right, Brendan. And just briefly, I will say, sort of as the final tips and tricks point, is arbitration provisions and mediation or ADR provisions are not one size fits all. So I do not recommend you take an arbitration provision from your user license agreement and just stick it into some specialized contract you may be negotiating with a new vendor who you're going to have a long-term master services agreement. Really think about what Brendan and I have talked about and try to tailor your ADR provisions to the type of arbitration or mediation that you want. I think we are all out of time today. We really appreciate everyone sticking with us through this. We hope that this was helpful in talking to you a bit about some ADR options you may have. If you asked a question we didn't get to today, we will try to reach out after this program and follow up with you directly. Certainly, if you have any questions you would like to talk with us about, our information is on the screen or on the internet, and we are happy to talk about these issues with you at any point. Thanks for joining us.